I think we're ready to go. Hi, everybody. It's good to see you. We are doing the litigation/risk panel, which I hear is the most popular one at this conference. In any case, we're going to make it as much fun for you as we can. So maybe we can start with the introductions. Perry, do you want to kick us off?
Hi, I'm Angelino, so not too many boos, but came in for the conference. I'm the managing partner of Baker McKenzie in Los Angeles. I'm also the chairman of Baker McKenzie Securities Litigation Practice Group in North America.
Great.
Nice to meet you.
Great. And my name is Yelena Dunayevsky. I'm a senior vice president, and I had the SPAC group at Woodruff Sawyer, which is a Gallagher company, one of the largest insurance brokerage firms in the world. And what I do at Woodruff is I help our clients, SPAC teams or companies that are looking to merge with a SPAC team, go through their risk analysis, figure out what they need to be protected against, and structure and place their directors and officers' insurance policies. And I want to just say that I've been doing this for a very long time. And I also, in conjunction with my work at Woodruff, run a blog entitled SPAC Notebook, where I post a lot of educational materials for the teams and all of the investors relating to SPAC risk. Thanks.
Great. Good morning, everyone. My name is Mike Hines. I'm a capital markets partner based in Sidley's New York office. I've been with the firm for over 20 years. I also am co-leader of Sidley's SPAC and de-SPAC practice and have worked on SPAC and de-SPAC transactions since 2015.
Great. So I think I was going to kick this off by giving a little bit of an overview of what we're seeing in the litigation / risk environment that relates to SPACs. And I just want to also say that prior to joining Woodruff, I practiced as a capital markets transactional attorney, so I understand some of the fear that some of the attorneys have when they are looking at insurance and making sure that their companies are protected. So what we are seeing this year is actually a little bit of a better situation than in some previous years. I'm going to talk about the rate of securities class action filings and also the settlements related to them. And the reason we're talking about these things are, of course, because they end up being very expensive. And when they are expensive, that's when you need to start looking at backup as your, in the form of your insurance policies to make sure that you're protected as an individual and also that your company is protected. So what we've been seeing in the securities class action filings for the last year, we're actually down to about 12 for 2024, and that's a reduction from about 30 for the previous 3 years, so that's a good sign. You have to remember that a lot of these are coming out of the business combinations from 2020 and 2021, so it takes quite a long time to get to first even the filing of the lawsuit, and then further down the line, the settlement of the lawsuit. We are likely to see fewer of them because, again, in 21 we had a lot of deals, not so many since then, so likely in this, at least for now, we'll see fewer. But if this wave of new SPAC IPOs continues, probably 2-3 years from now, we're going to perhaps see an uptick. The other interesting trend that I'm noting is that while we've been seeing mostly the securities class actions as the first wave of lawsuits against SPACs, particularly last year and possibly 2023, we started seeing a lot of fiduciary duty cases in Delaware. And we're going to talk about that in detail, but those are, I guess, a more favorable outcome for a lot of the plaintiffs based on some of the decisions from Delaware that we've been seeing lately, and so they're bringing more of those lawsuits, kind of similar to Multiplan, following in the footsteps of Multiplan. So we're likely to see more of those continue. Those are expensive, and so looking at the settlement numbers now, those are just the filings, the settlement numbers, 15 securities class actions settled in 2024 for a total of around $305 million that we saw. That's a significant number, definitely a much bigger number than we've seen in previous years. And even beginning of this year, there were 2 large ones. Maybe, Perry, you can touch on them later. In January, we saw a $126 million settlement for Alta Mesa, and then $80 million settlement for Grab Holdings. Those are the largest SPAC-related settlements that we've seen ever. So large numbers, which is why you need to really think about the risk and make sure you have the protection that you need from the insurance D&O coverage. Perry, do you want to?
Sure. So, under the last administration, SPAC was basically a four-letter word or acronym. Hopefully, under this new administration, it'll be a lot better. I think regulation will roll back under the new, under Atkins, and I think that hopefully securities litigation will calm down a little bit. Also, you're seeing a lot of a pivot to Cayman Islands as opposed to Delaware because of the controversy. On the heels of what Elena said, yes, the recent settlements say that the settlements in the SPAC context have been huge. And as Elena said, Alta Mesa, $126.3 million, that's enormous in securities litigation. It didn't go to verdict, but it did go to trial. And in the, as Elena mentioned, in the Grab Holdings case, $80 million. So it's something you really want to pay attention to. You want to take a look at the trends. You want to make sure that you've got adequate D&O protection, which we'll cover later. But the interesting thing is that most cases in securities, SPACs included, don't go to trial. The PSLRA, which is the Private Securities Litigation Reform Act in 1996, because of the obstacles to getting past a motion to dismiss, meant that most of the cases would either you win on a motion to dismiss. Our firm has about a 98% success rate on motions to dismiss, or if for whatever reason it gets past that, then you pivot into a settlement. But they rarely go to verdict, although our firm in the Brown versus Matterport case, which I'll mention, is the only firm that's gone to verdict in one of these cases, and we won. Big, actually, $80 million. So, so it's while you don't go to trial, the litigation's expenses, as Elena was mentioning, can be extraordinary. So you have to really watch out what you're doing and make sure that you make your transaction documents are good prophylactically, so that if you're in litigation, your litigators have something to hang their hats on, and that's really the way it goes. So in terms of significant new trends, especially in New York, there's been a series of cases brought by hedge funds, the most notable and first of which was Alta Partners versus Getty Images. And this was a situation where they're challenging the warrant agreements after the de-SPAC M&A concludes. So it's a breach of, basically a breach of contract, breach of warranty agreement, but those can be really large as well, because the first case that, it didn't go to trial, but it resolved on a motion in Alta Partners' favor for about $88 million. It's up on appeal now. And it's triggered a series of similar cases. The Tang case, Tang Capital case, is another similar one. And it's funny because with all the hits in front of Judge Rakoff, who has all these cases, when one of our clients came to us, LifeZone, a company that went through a SPAC, and they were facing a similar claim from Alta Partners, we pivoted and we realized that Judge Rakoff, we don't agree with the ruling. We think it was, a bad law was made, but we realized the Second Circuit just wasn't that friendly. So we figured that the key principle in Alta was, for tax advantage reasons, as a Puerto Rico resident, First Circuit was a lot more favorable. So we filed a debt relief action in Puerto Rico challenging the deal, the transaction, and raising two issues for the judge in the debt relief action. One is, given what happened in Fierro and in Keener with the Section 15 cases, we turned it on its head and we said, we asked the judge to weigh in as to whether or not Alta was acting as a unregistered dealer in these transactions, given the number of deals they did and the number of shares they traded. And if we were right, we asked the judge to say under Section 29 that he should rescind the transaction. Because it was such an unusual case, Reuters picked up a copy of our complaint, and the case settled 2 days later for a de minimis amount. So there are ways to combat these things if you really think about it. Other litigation, has been like the Greenland Asset Management case, which deals with best effort clauses in contracts. The multi-plan case in Delaware, as Elena was mentioning, all about whether or not the redemption process is handled appropriately from the judge in Delaware's perspective. It looked like all the motions were going to be denied as a result of that case, but then you had In re Hennessy Capital, which shifted and went the other direction. And then more recently, you had the Mountain Crest case, which is kind of reverting back to where we were. So, the concern is obviously when you're at the point of the de-SPAC M&A and you're sending out opportunities for the shareholders to redeem, to be careful that you say exactly what the value of the shares are so they can make an informed decision. Because if you say that it's $10 a share and post-de-SPAC M&A it's suddenly $7.25 because of the dilution issue, you can bet that a Delaware judge will look at that and think that that might be a bona fide misrep claim and not let it get past a motion to dismiss. The case that I was mentioning that we tried to verdict, I think it's the only case that's been tried to verdict, it was Brown versus Matterport. And similarly, it was dealing with protections of a shareholder, the former CEO, Brown, and it dealt with a dispute over locking up his shares. And we ended up prevailing, and that was an $80 million victory for the client in that case. And it challenged the efficacy of the transactional documents that were written because it all turned on that. And that's why it's really important that the lawyers that you have doing the transactional work know exactly what they're doing and know the litigation risk at the same time. In fact, the way our firm does it is the litigators on my team look over the transactional team's shoulders just to make sure that if it ends up in litigation or worse, an SEC investigation, that they're adequately protected.
Yeah, and I would absolutely second that, and Mike is going to, I'm sure, support it. And I want to just say that some of the attorneys that do this and have been doing this for a long time in the SPAC space, not only the transactional ones, not only check with their litigators on where the holes might be, but also call us, the insurance brokers who have done this for a long time, to check on how the policies would potentially cover some of those gaps and how they should draft the agreement around what the policies would typically cover.
I guess on the SEC side, I guess in terms of rulemaking, I think there was some discussion at the beginning of this current administration about whether the SPAC rules would be repealed or withdrawn or modified. I think we haven't seen momentum on that front. I think the market has largely adopted to the new rules that took effect July 1st of last year and were released in a proposed form earlier than that. And in terms of enforcement action and activities, obviously in the last 2 years of the Biden administration, there were a string of cases, I think, Digital World, Northern Star 2, Cantor Fitzgerald in December of 24, that I would sort of refer to as kind of pre-identified target situations where the SEC Enforcement Division brought cases against SPACs or SPAC sponsors for violations under Section 17 of the 33 Act, Section 10 of the 34 Act, basically boiling down to do you have material misstatements or material omissions in your IPO S1 or de-SPAC S4 or both. If you have had discussions, substantive discussions with target companies before the completion of your IPO, and talking about sort of the length and extent of the duration of those discussions in the background section of your S4. I think in those three cases, the SEC found there were substantive discussions with targets. In some cases, maybe handshake agreements on price or valuation that were not disclosed and resulted in very significant civil fines. I think in one case up to north of $15 million. So. What are the takeaways from those cases? I think, one, when we're, and usually this is a scenario where it's, a serial SPAC sponsor, right, that they have an established sort of M&A pipeline of targets that they have in mind. They may have more than one sort of live SPAC at any given time. I think it's, if you're, it's not that ideally you're not contacting targets before you're done with your IPO, but if you are, not engaging in substantive discussions on deal structure, price, valuation, certainly nothing in writing in terms of like a signed letter of intent or anything like that, or any sort of like handshake agreements on key terms, right? You want to stay away from that to avoid potential disclosure issues. Under the current administration, we have not. I think there's been a shift in priorities more towards, the enforcement priorities, focusing on sort of retail fraud, Ponzi schemes, insider trading, less so on the SPAC front, at least so far as I've heard so far. Projections obviously continues to be a very, very hot button area. Obviously, just to level set, like the liability, and sort of scrutiny around projections has sort of continued to be heightened under the new SPAC rules. Obviously, the PSLRA safe harbor was removed. We still have the bespeaks caution doctrine, but target companies are now co-registrants for like a D-SPAC S4 or F4, so they carry enhanced liability on projections disclosures. It's an area, obviously, that gets a lot of focus from the SEC staff during review, and we get a lot of comments on registration statements. So how to think about projections, I guess, when I'm advising, especially targets, but also on the SPAC side, I think one of the first questions I ask is sort of, do we need projections in this deal, right? I mean, we've seen a shift and a preference in the market towards more established target companies, businesses that have like a track record of revenue and cash flow, generation, who may or may not need sort of a pipe financing right up front. They may just be looking for a listing through, that's their ultimate goal through the SPAC process. Can we, in those, in cases where a pipe financing may be needed, if it is a mature business, can we rely on the historical financials? Is it really necessary to disclose projections or market off of those? Do you have a fairness, not every deal has a fairness opinion, where those are provided. I guess, it's hard to get away from projections, but can you limit it to, can the fairness opinion provider rely on like a comparable transactions or precedent companies analysis rather than like a DCF or discounted cash flow that usually requires 3 to 5 years of projections, of detailed projections? Sort of working through that whole analysis, and okay, if we absolutely do need projections for X, Y, or Z reasons, sort of going through those with a fine-tooth comb, limiting the, I think there's definitely been a trend in favor towards, 1 to 2 year projections as opposed to 3 or 5 or longer, and also sort of limiting the line items that obviously get disclosed in those projections. And then, of course, having very robust, there's the new sort of SK 1609 requirement as part of the SPAC rules, but, just having robust disclosures around who prepared the projections, the purpose of them, what are the key bases and drivers for each one, and what are the assumptions, if there are critical inputs, like the market price of gold, for example, including sort of what is that assumed, market price, and including even a sensitivity analysis of how the projections would change if the market price were to go up or down. And then one thing that's I gotten a lot of attention in deals I've been working on is sort of as part of this new SK 1609 is sort of there's a required statement that the target management team say, does this continue to represent the view of management as of like the most recent practicable date? Well, as de-SPAC transactions have historically taken longer and longer to complete, it's frequently the case that the projections may no longer be, accurate, or things have changed or need to be revised. So it's led to some difficult, discussions around, well, do we need to update the projections or talk about sort of, just qualitatively, where we think we're going to come out relative to what we put out maybe 6 or 9 months ago. So, it's obviously an area that continues to get a lot of focus, and I think we'll continue.
I could definitely say what Mike's saying is all very real. There's a firm that was representing a company called Momentous that was terminated. We were brought in because of the high risk nature of it. It's one of the cases in the SPAC context that had heavy duty SEC enforcement. And for a good reason. The CEO, or the former CEO of Momentous, was a Russian national in a U.S. space exploration company. So it got to the point where the Department of Defense sent a demand letter to the SEC saying, you guys need to look at this. So we got brought in to help put all that to bed and deal with the civil securities litigation. But a lot of these cases do have the capacity to have SEC enforcement, and with that, obviously, Department of Justice to U.S. Attorney involvement.
Yeah, and whenever you have enforcement, even a hint of enforcement, right, that always translates into additional costs to try to bring in the attorneys to make sure you handle that, and that then for where I'm sitting from, it translates into, okay, is our D&O insurance going to cover that, right? So, but generally speaking, when we are going up and negotiating against the insurance carriers on behalf of our clients, if the teams are handling the projections in a sober, intentional way, and if they're not doing interesting, risky things, the carriers like to, they do their best to try to bring down the cost of the premium, and that opens an avenue for us to really negotiate and make sure we get the right coverage at the decent cost. And so I was going to talk a little bit about some of the trends we're seeing on the insurance side specifically. The recent Delaware amendments to DGCL have been helpful. They're just kind of making their way through the insurance underwriter space as they're digesting the fact that some of those amendments are going to be helpful to de-risk or slightly de-risk the SPAC vehicle. A couple of the questions that come up that I find interesting from our clients is, okay, so if we're going to incorporate outside of Delaware, is our insurance going to be cheaper? That's an interesting question. Obviously, there's been a lot of litigation there. That's why a lot of the SPACs are now outside of Delaware, Cayman, and so on. So if you're on a SPAC IPO side, definitely if you're not in Delaware, insurance is a lot more accessible and less costly. If you're on the de-SPAC side, and I know there's been some recent movement towards Texas or Nevada, I wouldn't say the carriers are jumping up and down to give you huge breaks on their coverage if you move out of Delaware to Texas or Nevada, because those jurisdictions are still sort of an unknown. They don't know what that's going to look like in a couple of years once the lawsuits start popping up, right? And also, we're coming out of a very, very long, soft market on the D&O side where the pricing has just been really, really low. And I don't know how much more room the carriers have to bring that pricing even further down. But it is something that everyone should keep an eye on and keep thinking about those considerations as they're talking about risk and how to manage that and manage the costs of both the SPAC IPO and the de-SPAC.
Can I jump in for a sec? So,
Sure.
As a litigator, I get involved and jump in after everything is blown up. And so I look at things with the benefit of hindsight, D&O coverage and things like that. And some companies have $5 million in D&O coverage, which, just as a footnote, is absolutely inadequate if you're involved in a securities class action. I'd say the line is really about $10 million if you want to be protected as an officer or director in a public company in a SPAC context. Look at your retention number, because if your retention's $2 million, that means the first $2 million's on the company. And, and the other thing I would mention is because there's always the possibility of an SEC investigation or enforcement action, a lot of times in insurance policies, even if it says $10 million in coverage, it doesn't mean $10 million for an SEC investigation. A lot of times you'll see a separate category just for that with maybe $100,000 in coverage just for the SEC side of it. So you should be mindful when you're getting involved and getting on the board of the companies to make sure there's adequate D&O coverage to cover you without too high of a retention and with an SEC coverage component too.
And that component of coverage, that is a discussion you need to have with your insurance broker. If the insurance broker is knowledgeable in the space and does this day in and day out, you don't even have to ask that question. They're going to bring that up and make sure that you have sufficient coverage there and it's not going to be $100,000. If the broker does other things most of the time and occasionally does SPACs, they will not know this, they will not focus on this, so it's really, really important to make sure you're working with the right person there. In terms of limits, I just want to say the question always pops up, okay, we're raising X amount of money for our SPAC IPO, how much of a limit should we get? I think the way to think about it is really not so much at how much you're raising, it's more about how much are those costs going to be to try to get yourself out of that lawsuit? Because the attorney costs are high, and it doesn't matter if you raised $500 million or $50 million, because those costs are not going to go away. They're going to be very similar to get you out of that lawsuit, even if it's a frivolous lawsuit. So you really need to think about how much is that going to cost, rather than how much is it going to be in relation to how much money I raised on the SPAC IPO.
And a related issue to D&O coverage are the indemnity agreements, and no one looks at an indemnity agreement until after a lawsuit hits, and then it's too late.
That's right.
One of the things that amazes me, and this is the flaw when you have only transactional lawyers looking at the deal before it closes and not litigators, is that, and it depends on whose side you're on, right? So if you're officer or director, you want the indemnity to be as broad as possible. If you're the target, the surviving public entity, you want it to be as narrow as possible because you're the one who's going to be holding the bag, paying for it. So if I'm advising an officer or director, make it as broad as you can. If I'm advising the target, narrow it, and not just narrow it, but make sure it dovetails with the D&O policy. And here's why. D&O policies oftentimes restrict your choice of counsel to panel counsel. And if you don't use someone that's on the panel for that particular insurer, the insurer will say, we're not paying it. The other issue is the rate cap. So imagine this, imagine your D&O policy caps the rate at $500 an hour, which is something that no law firm, at least no law firm in New York, is at $500 an hour for securities class action. But if your indemnity agreement lets you choose counsel and says nothing about any constraint about rates or anything like that, and you're the target, you're left holding the bag. You're going to pay the delta between whatever the D&O policy says and what that indemnity agreement says. So I would take a really good look, depending on which side of you're on, whether you're in the company side or the officer's director's side, as to what that indemnity agreement says.
But in any case, even regardless of which side you're on, I think you all need to be in agreement to understand how the indemnity is going to work. Because you don't want to, even if you were able to negotiate a very narrow indemnity, you don't ultimately want to upset your SPAC team down the road when they realize, oh, oops, nothing is indemnified and no one's going to be paying for our D&O coverage because we didn't talk about it. So it's really important to make sure you have those conversations before you sign that, before you close that deal, and that everyone's on the same page as who's indemnifying whom, how much and for what, and who is taking care of that tail coverage potentially for the SPAC, or if it's combined into the post-merger combined policy, who is paying for that down the road in year 2, year 3, and so on.
And I could tell you, the case I mentioned before that we were involved in that had both an SEC enforcement side as well as civil litigation, the Momentous case, we had a situation where the indemnity agreements were ridiculously broad, and we were scratching our heads, how do we protect the company? Because we were representing the target, the target of the surviving company in the de-SPAC M&A. And the former CEO, Kokorich, who was the Russian national, was between the SEC enforcement action and defending the securities litigation. It was like this blank check, and he wanted to choose his counsel, and the legal fees were more daunting for the target than the exposure risk in the case. So we actually made law by going into Delaware, and we narrowed the scope of the indemnity agreement in that matter, which is really hard to do, but we did it. And so it's a lot easier, as I said, to do it on the front end, because we didn't draft the deal documents, but we had to live with them once they were drafted.
Yeah. I would just highlight it being the sole sort of deal lawyer on the panel. Like the indemnity agreements, like they oftentimes get not a lot of attention and pushed to late in the de-SPAC process. And if you're representing the SPAC, a lot of times you'll let the target counsel drive those because they're going to have to live with them. But having been on the other side of one of these with a sponsor, who had litigation after the deal, there are a lot of pitfalls in those indemnity agreements, and it's definitely worth getting someone like Perry or Yelena to look at those, while you're doing the deal before they get finalized for sure. And just, Yelena, to hit on one thing you mentioned too, just with, if you're on the front end thinking about where to incorporate the SPAC, I know there'll be a panel later today about this, but don't want to steal their thunder, but go Cayman for sure, for a lot of reasons. I mean, not just the litigation climate in Delaware, accessibility of insurance, but obviously the sort of significant sort of excise tax that applies for 1% on redemptions for domestic SPACs that you don't have with Cayman or other offshore vehicles.
And the other thing about Cayman, and I'm not a Cayman lawyer, and there's going to be a couple of panelists down later today that are going to have Cayman counsel on, so you can ask them all the difficult questions. But I would just say that for Cayman, the insurers see it as a less riskier jurisdiction for couple of reasons. One is that in Cayman, loser pays the attorney fees, which is not the case in Delaware. And so you get to reduce the number of frivolous litigation, which we've been seeing a decent amount of in the US. So that's a huge thing. And also, I mean, think about, there's not been a lot of precedent in Cayman that has been as negative towards SPACs as we've seen elsewhere. Now, you know, a lot of the clients say, well, is it 100% proof? There's never going to be litigation if we go to Cayman. That is never something you can say yes to. There's always a chance, and I'm sure we're going to see some litigation now that all of these companies are going to be in Cayman. But compared to some of the jurisdictions, specifically Delaware in the U.S., it's definitely a less riskier proposition at the moment.
And if you're choosing, you know, obviously it depends whose shoes you're in. If you're the one investing in the SPAC, you want to be in Delaware, not Cayman Islands. But if you're the one who wants the protection, if something goes south, I agree, Cayman right now. But you know, the jury's still out, so to speak, metaphorically, because under this administration, the pendulum can swing in a whole different direction. And I think it's going to be a much friendlier environment to SPACs, whether it's in Cayman Islands or Delaware.
Yeah, remains to be seen. I think we have a couple of minutes, so maybe we'll do our closing takeaway, crystal ball kind of remarks. Mike, you want to start?
Sure. Look, I think we're going to continue to see, you know, like the average SPAC IPO, which obviously been booming this year, is I think smaller. You know, I think it's like 150 million average SPAC IPO size for 2025 year to date, compared to, you know, a few years ago where we saw multiple that were, you know, over 500 million or a billion. I think we're going to continue to see that trend. I think there's a preference towards like smaller, more manageable SPAC sizes, less dilution, you know, on the back end, and, you know, obviously lower sort of upfront costs. I do think that we're going to continue to, I think on the SEC, we've seen signs that it's going to be a more user-friendly SEC when it comes to the sort of de-SPAC review process. They've put out guidance, not necessarily specific to SPACs, but for all issuers, and expanding sort of the confidential submission process for draft registration statements available to all public companies. I think there's signs that the SEC review will be more targeted and a little bit more streamlined than in previous years.
Great. I have 3 things to think about that I think could be useful for everyone. So I think many SPAC teams have learned their lessons from a whole bunch of litigation that we've seen so far. So they're not doing things that the insurance underwriters hate, like wild projections or, you know, getting into serious discussions with the target company before they get the IPO going. Like, people are trying to avoid keeping all of the termination fees. They are trying to disclose everything they can about dilution and definitely about conflicts of interest. So generally speaking, the market is behaving a lot better than it was in the past, which means from the insurance side, things are less risky, which means better coverage, better terms, right? So that's good. I'm hoping that will continue. The one thing I am a little bit worried about is that last year when we were at this conference, people were saying, listen, I think a good SPAC market should have somewhere between 60 and 80 SPAC IPOs a year. We're already at 57, right. So I'm feeling a little nervous right now. But I am, you know, I'm being optimistic. Hopefully it's not gonna devolve into what we saw in 21. And then I'll finish with insurance, because, you know, that's what I do. Insurance D&O pricing has been great last year, this year. It continues to be very, very minimal compared to some of what we've seen in 21 and 22 and so on. If we're going to continue seeing this frequency of new SPAC IPOs, it might start inching up. If we're going to start seeing traditional IPOs, I know there's been a couple of names that just went public, carriers will start raising that price. But for now, it remains very, very affordable and doable. So we're in a good spot right now.
And I think you're going to see a lot more activity in the SPAC and de-SPAC market now. I mean, the IPOs were pretty much silent, other than the deal that you mentioned from last week. But SPACs are definitely gaining momentum, and they just tend to be more nimble than an IPO. And I think that, with a rollback, given that Atkinson is now heading up the SEC, and there's going to be less regulatory scrutiny, I think people are less afraid or concerned about being on the board of a SPAC or doing a SPAC. As I mentioned, in the Delaware, the landscape of SPACs in the law is rapidly evolving. So just make sure you check in with your counsel to make sure that you're doing everything consistent with the latest in the law. Be careful if you're doing the deal, as I said earlier, that the D&O coverage is adequate. Be careful that you have SEC enforcement coverage. Make sure that, and when I say adequate, 10 million in coverage, not 5 million, because I've been there. Because what happens is if there's 5 million and the settlement, because the way these cases happen, just briefly, is the plaintiff's lawyers will figure out what the policy limit is. And usually you can guarantee the fact that the case will settle within the policy limits, unless it's really, really low, like 5 million. And then you'll have situations, right, where the company has to dig into its own pocket to pay the difference, or its officers and directors, and you don't want to be there. So just be safe in doing it, but I think SPACs are definitely you're going to see a lot more momentum as this year builds.
All right, great. I think we're done.
Thank you.